Welcome back to Courtroom Chronicles, where justice is never quiet. Today's case centers on Zuli Valicia, a Texas woman who pleaded guilty to burglary, but insists she never stepped foot inside the house. The twist? Her car was used in the break-in, and the evidence paints a very different picture, with conflicting stories, missing accomplices, and a judge who's not easily convinced. This sentencing hearing is about to take a dramatic turn. Stick around, because this one will test what it really means to take responsibility.
I've reviewed the PSI with Zuli. I know that obviously her version, the court has questions about that, and so I would allow her to address that if she does wish to move forward in hopes of obviously us arguing for the probation.
So here's the thing. If you say you didn't do it, you don't get to say I didn't do it, but please give me probation, because then you're not accepting responsibility. So either you did it, what they charged you with, or you didn't. And doing it doesn't mean that you participated fully. And I'm sure Ms. Holmes has explained to you the law of parties in Texas and what that means. But if you say somebody took your car and you weren't even there and you had no idea of it, then that's what juries are for. Because you are about to take the chance, if we go forward, of me sending you to prison for 7 years. Me possibly giving you probation. But I can assure you that you're not going to get any kind of help from me if you get up here and say, well, I didn't really do it, but come on, give me probation. Does that make sense?
Yes, ma'am.
So tell me, if you want to go forward, tell me exactly what you did, what your part of this was.
I was aware of what my car was going to be used for. I didn't participate in the act, but I knew.
So you didn't drive your car?
No, I did not. I did not drive it at the scene where it happened.
Mr. Nichols, it appears that
if I'm explaining myself.
I think what she was trying to say, Your Honor, she wasn't present at the scene of the burglary, but let them use her car and I guess drove them close by. Because we know she was pulled over driving that vehicle on the way.
I mean, there's cameras from Lieutenant Hudson's cameras that confirm that you were driving when you were stopped.
Yes.
With the other guy seated in the front seat.
I was in town when it happened, but I was not at the scene.
So yeah.
So when did he get in your car?
When they brought it to the crime scene, but I was not at the crime scene. I'm
very confused.
So she drove here to Groves. She drove into town. She was aware of what was going to happen.
You weren't aware of it. You drove in to be a part of. You knew. I mean, there's saying I'm aware of whatever. Y'all came into town. With,
can I rephrase myself?
You probably should real quick, because hang on.
I was not at the crime scene.
Hold on. Because y'all came into town with radio jammers and fully ready with medical mask and face mask and all this stuff to come in from out of town to do what you did here in our town. And so you weren't just riding along and then they said, oh, by the way, sorry you came with us. We're going to do this.
Okay, well, I drove because I'm the one that had.
And there it is, the moment of truth. After minutes of confusion, Zuli finally admits she did drive them to the crime. You can almost feel the air shift in the courtroom. She claims she only drove because she had the license. But that logic doesn't hold up well under Texas law. What do you think? Should someone who helps plan and drive to a burglary get the same punishment as the ones who went inside? Drop your thoughts below. This part always divides viewers.
License in case we got pulled over.
Okay.
I was not at the scene.
So you brought them to do the crime.
Yes, ma'am.
It's not that hard to say.
Yes, I didn't know how to rephrase myself. I'm sorry.
All right. Ms. Holmes, go ahead with argument.
Yes, Your Honor. She does not have an extensive criminal history. As you can see, there is one prior, looks like a theft of property, which she received 6 months state jail. And then there was a federal case as well back in 2020. Ms. Zuli is currently employed and working. She would like the opportunity to continue that with probation. She does care for family members as well, Your Honor, and for her household. As indicated in the PSI, they do have her at a low risk level, which I believe is indicative that she would be successful on probation if given that opportunity. They've also stated in the PSI that they would like her to adhere to any mental health services and comply with those recommendations, as well as the more recognition therapy program, and to obviously stay off of any premises in which this act was committed. To her credit, they did state that she did express remorse for the actions, and she felt embarrassed for her family and does regret that. Your Honor, it's also stated that based on her statements, history, and circumstances, she does appear remorseful and motivated to make positive changes, which I believe that she can do if given that opportunity on probation. She can get, obviously, up to 10 years, and if the court deems that, we are asking that she be able to do the 10 years probation to give her that opportunity to show that she can be a productive member of society, and to possibly, if the court deems necessary, if she can have the opportunity at deferred probation to have that time to rehabilitate herself and to hopefully not have another felony conviction on her record.
Mr. Nichols?
Your Honor, I echo the sentiments of Detective Hudson and, Lieutenant Hudson. This wasn't just a crime of opportunity or one-off incident. This was an organized burglary that involved high technology, that involved planning, and a target of this individual's residence. They came in from Houston specifically to burglarize this home, and they did. And I think there's obviously, she flat out lied to the police about being there, driving. She claimed that her car had been reported stolen 2 days before this, even though she was stopped and was on video driving the morning of. So I think the 7 years is appropriate. I'll note for the court, the co-defendant got 10. At least one co-defendant got 10. I'm not sure on the others. But I think 7 years is appropriate.
This just escalated. 2 of Zuli's co-defendants reportedly fled across the border. That means Zuli is the only one left standing in court while the others vanished. From a judge's perspective, that's a red flag. She's suddenly the face of a crime crew that can't be fully held accountable. And when she says one of the men was her brother and another her barber, you can feel how tangled this story really is. Family, trust, and loyalty, all colliding in the worst way possible.
And given the instance of this case.
How'd y'all pick this person?
Sorry.
How did y'all pick this house, this person, to come in?
No, like I said, the only reason why I came here was because I had the license. So in case they got pulled over, they didn't have a way to prove their citizens. So I was just like the one that drove into town. I don't know about the.
If I can, 2 of those individuals have fled the border. They were not legalized, so they probably will never be found. So there were 2 other individuals involved in which she has tried to get contact. So that's the reason why they were involved. She was the driver, but they have since fled the country. They're not coming back. That actually went into the house. There was only one that was caught that received the 10.
Mm-hmm.
So I think that's what she's trying to say is she was driving because they obviously did not have the credentials to do that. And we don't know where they are.
So do you know why y'all came to this house?
I have no idea. The only reason that I came into town was because I'm the one that had the license. So in case they got pulled over, they didn't have a way, to prove their legal
How many
status.
other times did they have you drive you to other places?
No, that was the only time I did it, and I regret it. It was crazy.
Your Honor, if I may, I had the co-defendant's case. The victim in this particular instance was a local business owner, owned a donut shop. They also owned a donut shop in, and forgive me if I'm off on this exact city, I think somewhere in Humble, or nearby in Humble. That business, their home in that city was also burglarized.
Right. So, thank you,
I
Mr.
cannot show you I was not involved in any other situation that had to do with them. It was just a one-time thing.
How did you know these guys?
Well, basically, one is my barber. The one that's doing time, he's my barber.
He's your brother?
Barber,
Barber.
yes.
What about the other 2 that took
No,
off?
I never knew them.
So where do you live now?
I live in Houston, Texas. Yeah, Houston.
Do you work?
It's
Where-
50 hours a week.
For what? For who?
It's integral. It's basically for the state. I get paid $25 an hour.
To do what? I'm sorry.
I don't know how to describe it. It's like solar panels. Like, it's for the state.
Okay.
I have evidence as well.
You have what?
Evidence that I'm working there.
Okay.
Before that, I was working in a car wash, but they offered me more there.
So I don't disagree with Lieutenant Hudson or with Mr. Nichols because of what happened and the targeted way that this happened. It does appear that the guys were probably in charge of most of this. You made a really, really stupid decision.
Yeah. And I regret it.
Yeah. All right, what I'm inclined to do, because what you're charged with is a second-degree felony.
Yes, ma'am.
So the range of punishment is up to 20 years if you went to jury, or all right, here's what I'm going to do. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. You're going to be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. So let me explain what that means and why that's good for you, but probably more so for me, and why I'm doing this. So a deferred probation means you don't have this conviction on your record. But what it also means is if you violate any condition of probation, you will be brought back into court, found guilty, so you have the felony conviction, and that cap of 7's gone. I have the full range of punishment between 2 years and up to 20 years. And certain cases, for whatever reason, the fact that this one, I remember it from Mr. Coleman's case, from the co-defendant. I'm likely to remember it. It's never good when I remember things, okay? And so I'm going to order also that you obviously have no contact or communication with any of the co-defendants. If they've fled the country, whatever, if they come back, if they try to contact you, you cannot have any contact with them. In fact, I'm ordering if they contact you, that you contact your probation officer and law enforcement and let them know any information that you have about where they are. You will be, I want her on the medium-high caseload to start off with. It means you're going to be reporting more often, making sure you get off on the right track.
I work like an hour from my house, so I leave the house at 2:30 and come back home at 2:30 in the morning.
So talk to probation. I want you to work, okay? And so you need to get them documentation of your schedule, because there will be a curfew except for employment purposes. You'll be required to report in Harris County, but you're also going to be required to report by mail or online here. So you kind of have double duty. You've got to do it all. If you don't report by mail or online here, it's a violation. If you don't go in person there, it's a violation. If you don't give them proof.
In the end, Judge delivers a rare balance. Firm justice with a chance for redemption. Zuli walks out on probation, not prison, but under strict watch. The takeaway? In court, honesty and ownership can make the difference between 7 years behind bars and 10 years of rebuilding your life. What would you have ruled here? Probation or prison time? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Only here on Courtroom Chronicles. Welcome back to Courtroom Chronicles, where every gavel strike tells a story. Today, we're stepping into a Texas courtroom where Judge Stevens faces two very different defendants. One accused of evading arrest and failing a drug patch order, and another caught up in a theft case with thousands on the line. From excuses to emotional reality checks, this hearing has it all. But the real question is, can honesty save them from a harsher fate, or is the judge already out of patience? Let's find out.
The third-degree felony offense of evading arrest or detention with the use of a vehicle from June 7th of 2025. And then in cause number 25, DCCR 1164, you're charged with possession of a controlled substance, and that's also from June 7th of 2025. Since you've made your bond in your cases, have you had an opportunity to try to hire a lawyer? So have you hired someone?
Not fully, but I'm for the, he basically my lawyer. I gotta go pay him today.
Who's that? Okay. And are you wearing a drug patch?
No, no.
Were you ordered to wear one?
I was, but once they changed my bonding company, they professionally didn't tell me about lunch.
So, but the magistrate told you you had to wear one when you got out of jail, right?
No, I'm on 2 different bonds. So I guess the other bond I was on, I had already got done paying them off, so I didn't have to pass for them anymore.
Okay, so you're gonna have to wear one for me, but what first we're gonna do this morning is have you tested to make sure you're clean. Have a seat in the jury box. Mr. Allen? When did you smoke marijuana last? So here's the thing, you need to tell me the truth, because I'm gonna get a quantity amount, not just that you're positive, but I'm gonna get how much is in your system. And so I need to know when you smoked it last, so that if I find out next time it's not going down, things are gonna be worse. So when did you smoke? When did you smoke last? Day before yesterday. So
Now this is where things start heating up. The judge's tone changes the moment Rake admits he smoked marijuana just 2 days before court. That's not just bad timing. That's poor judgment under supervision. Legally speaking, when you're out on bond, you're still under court orders. Any substance use, especially after being told to wear a drug patch, is a direct violation. The judge is testing not just his honesty, but his accountability. Question for you all watching. If you were in Rake's shoes, would you admit it, or try to talk your way out of it?
that's why you weren't wearing your patch.
No, really, I just, like I said, I'm on 2 different levels. I was already done paying my first one.
Right.
Now I'm on the second one. The first bill when I was on, that's for my blood pressure. I figured since I wasn't paying the bill anymore, I had to wear blood pressure. They haven't been
I know, that'd be really convenient if you had 2 felonies and you didn't have to wear a drug patch and you could smoke marijuana 2 days before court. That'd be pretty convenient, wouldn't it? So you're gonna have a drug patch today, within 24 hours. I know the first one will be positive, obviously. If the next one is not going down, then your bonds in each of your cases will be raised and you will be back in custody. No questions asked, you understand? So you have 24 hours. I want you to get confirmation of that to your bondsman. Even though you've paid your bondsman, they're still your bondsman. They're still gonna give you, just because you paid them off doesn't mean they're not your bondsman anymore. Okay, so even if you pay off the other one, you're still out on bond. You're still required to keep in touch with them. They're the ones that'll help you figure out when your court days and all of that stuff. So don't stop communicating with them, because even though you've paid them, they can get off your bond and you can go back to jail. So keep up with everything you're supposed to. I want proof to them by tomorrow or this afternoon that you have the drug patch. You need to make sure it's switched every 2 weeks like it's supposed to. Wear it properly. There's no going in and saying, well, it fell off, and none of that.
Even when I was on the blood pressure, I ain't never feel no good.
Okay, well, that makes me more concerned about your decision making if you were doing well and then you decided right before court to go smoke, right? Okay, step in front of the clerk. She's gonna give you a reset notice. You need to get a lawyer hired as well before that next court date.
Fine.
Oh, sir. That's not appropriate. First of all, pull them up. I know. Well, nobody wants to see your underwear. Not in court and not anywhere. Does anybody ever want to see your underwear? Right? And you need to wear something nicer when you're coming to court. Morning.
Good morning. We've emailed the attachment.
Okay, thank you. Good morning. Are you Michaela Marcantel? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Let me get to it. Ms. Marcantel, in cause number 25 DCCR 0528, you're charged with the state jail felony offense of theft of property from May 28th of 2022, continuing through June 4th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be $4,492.45 to be paid back in restitution, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Marcantel is not competent?
No, Your Honor.
And any reason
She's
not to
never been
waive?
arrested before, Your Honor, and I don't have
Got
an
the
objection
amount.
to waiving.
All right, Ms. Marcantel, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I'm going to waive the pre-sentence report. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation. I'm also ordering you pay back the restitution in the amount of $4,492.45. If you do everything that you're supposed to on this probation, this is an excellent opportunity because you are not a convicted felon. You don't have the conviction on your record. And if you successfully complete the probation, at the end, the case actually gets dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for up to 2 years. Do you understand? That's a lot of money to pay back also. 5 years seems like a long time to pay it back, but it'll sneak up on you. And so it is very important to me that you start paying back that money immediately, even if you
2 cases, 1 courtroom, and 2 very different outcomes. Rake Allen walks out with a warning and a drug patch order, while Michaela Markell walks away with probation and a second chance at redemption. Judge Stevens made it clear, this courtroom isn't just about the law, it's about personal responsibility. Every decision, every action, carries a consequence. So, what do you think? Was the judge fair today or too lenient? Drop your thoughts in the comments below. And if you found this case as eye-opening as we did, make sure to hit that like button, share this video with a friend, and subscribe for more jaw-dropping courtroom breakdowns right here on Courtroom Chronicles. Welcome back to Courtroom Chronicles. Today, we're diving into a high-stakes hearing that's about to spiral out of control. Meet Mr. Hancock, a defendant facing 3 serious charges, from evading arrest to continuous violence against family. The tension in this courtroom is already off the charts. And as the judge uncovers Hancock's long list of priors, the atmosphere turns explosive. Will the defense's plea for leniency hold up, or is this about to backfire big time? Let's find out.
5 DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first 2 cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So there it was, before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order. Oh, that was just filed in the case. Okay, it looks like that was from back in the arrest on, where's the date? April 26th. Okay, so I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge, I
the
think if you
bond.
just let me review his criminal history, your decision will be very easy.
I've already know what I'm gonna do, but I'd be glad for you to do that as well. Go
Yeah,
ahead.
he's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these 2 evadings, the state jail and evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off of parole about 2 months before the new offense date in April.
What is that? Let me look at something else that's new. I want to see what the bond is set at on the new case, 25 DCCR 1233. Because honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. Ms. Holmes, any,
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock did go to the hospital in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
really, you're aware of that? How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you you need to behave in jail?
No, no.
This is ridiculous. These people are just going to work and trying to do their job. That's all. You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to the officers, the female, they disrespect you first. Do you think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law.
Wow. This is the moment everything shifts. The judge isn't just mad, she's furious. When she says, "You've lost your right to make decisions," that's not hyperbole. That's the legal reality when someone repeatedly breaks the law. Hancock's attitude inside the jail, threatening officers, disrespecting staff, is destroying his own defense. Judges see this as a reflection of character, and it directly impacts bond decisions. And you can hear it in her voice. She's done giving chances. If you were the judge, would you have reacted the same way?
You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going, keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life on one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this. And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny the motions for a bond reduction in cause numbers 25 DCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in cause number 25 DCCR 1233 that your bond is insufficient. And in that case, I'm going to raise your bond to $100,000. A condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device and you will be on house arrest. So if you make these 3 bonds, you will be on house arrest. You're not allowed to leave your house unless you have my permission. And you will be...
In the end, Judge Stevens lays it down hard. No bond reduction, stricter conditions, GPS monitoring, and total house arrest if released. For Hancock, this means every move from here on out is under the court's watchful eye. It's a powerful reminder. Your courtroom behavior matters just as much as your criminal record. This wasn't just a bond hearing, it was a wake-up call. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts below, and don't forget to subscribe for more real courtroom breakdowns and unbelievable legal showdowns. Until next time, stay sharp, stay aware, and we'll see you in the next hearing. Welcome back to Lawful Verdicts, where the courtroom heat never cools off. Today's docket is wild. We've got 2 jaw-dropping hearings back to back. First, a mother who swears she's fighting for her son's future, but ends up facing drug charges that could take everything from her. And right after that, a repeat offender caught in a swirl of excuses, defiance, and shocking jail misconduct reports that leave even the judge speechless. How did things spiral so fast? And when a second chance turns into a courtroom disaster, who really pays the price? Let's dive in.
4 different attorneys. I have the printout paperwork. I got all the information. They're extremely expensive. I've not been able to get the funds gathered for that.
Who'd you talk to?
I spoke to another down
Where?
a month ago.
Where'd you?
Right in my phone.
Okay.
Our
Did you talk to some more since that last court date?
the last hearings.
Uh-huh.
You asked, you instructed me to get 3 quotes.
Mm-hmm.
That was what I did. And I can get that turned into you after,
Okay. If I test you this morning, you can have anything in your system? Have a seat in the jury box. We're going to text. Ms. Taylor, you tested positive for amphetamines, methamphetamines, and ecstasy. And so at this time, I'm going to find that that is a violation, obviously, of your bond conditions. And
there it is. The hammer drops hard. Testing positive for methamphetamines, ecstasy, and amphetamines while out on bond? That's a straight-up violation of release conditions. Under the law, when a defendant breaks bond terms, especially with serious narcotics, the judge can raise that bond sky high or revoke it completely. And here, judge isn't holding back. $100,000 per charge means Melissa's freedom just turned into a 6-figure problem. But what hits hardest is her plea about her child. It's a tragic moment. A mother claiming love while her own actions risk tearing that bond apart. What do you think? Does addiction excuse the choices, or does accountability come first?
to raise your bond in your case to $100,000. Well, let me look at it real quick. I'm going to, let's see. In one of your cases, you're charged with assault on a peace officer, the other credit or debit card abuse. In each of those cases, I'm raising your bond to $100,000 in each case.
Okay.
If you make the bonds in those cases, you are ordered to wear a drug patch at all time, get it tested at the appropriate times, and then we will move forward with your case.
Can I ask a question, please?
Mm-hmm.
Am I about to be arrested in?
Yeah, you're going into custody right now.
Okay, I have a child.
You shouldn't be using ecstasy and methamphetamine. If you have a child, you can go back with the bailiff.
So I.
Go back with the
have
bailiff
not
right now.
been-
Go back with the bailiff. Go with the bailiff.
My child is missing and he's with a terrible person.
Good morning, sir. Are you Christopher Paul Davis? And Mr. Davis, this is your initial. Good morning, sir. You're Denzel Lewis. And Mr. Lewis, you were previously in court, entered a plea of guilty to the third-degree felony offense of unlawful possession of a firearm by a felon. The agreement was for a cap of 6 years in prison. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Are there any additions or corrections?
Just argument from the defense.
Not from the state.
In addition, I have received the jail incident reports, which have been turned over to counsel. Have you both had an opportunity to review those?
I have.
Also, I have received this morning and now reviewed, it looks like 4 letters of support that Ms. Holmes brought today. Mr. Smith, have you had an opportunity to review those as well? All right, then Ms. Holmes, you may proceed.
Thank you, Your Honor. In looking at the PSI report, Mr. Lewis does have obviously previous criminal history spanning from juvenile and to adulthood. The priors that he has, it appears with burglary of a habitation. It looks like 3 cases, but they ran concurrently, in which he was placed on probation and had a revocation, in which he was sentenced to 8 years in TDC. He has since been discharged from that, Your Honor, and after being released, there was this traffic stop, which resulted in a firearm being found in the vehicle in which Mr. Lewis was driving. Obviously, in reading his response to the PSI officer, I would allow him to elaborate more on that. Obviously, he did plead guilty to the offense, taking responsibility, and we are seeking probation in this case, Your Honor. We believe that at this point in Mr. Lewis's life, he understands, obviously, being incarcerated before, that it's not somewhere that he wants to go back and spend potentially 6 additional years of his life. He would like this opportunity on probation to have that opportunity to spend and get back on track with employment, to take care of his family and provide for his family. And reading those support letters, Your Honor, he does have support here from family and friends in the community that are willing to step up and help him to make sure that he is a productive citizen and he gets back on track and understands that there's just certain things with being a convicted felon that he cannot do. And I think at this point he understands that, Your Honor, and we are asking that the court give him the opportunity to be placed on probation and to finish his term while on probation.
Well, I guess before we go any further, I want to make sure I understand, because Mr. Lewis, your version of this is that it wasn't your gun, it was in your girlfriend's purse, and you didn't even know her purse was in the car, much less the gun was in the purse in the car. So either you are guilty or you're not guilty of the offense. And so if you knew about it, then you're guilty. If you didn't, then a jury needs to decide.
I'm pleading guilty because I was driving the car, and by me driving and then finding the gun,
But the law, that's not what the law is. Okay? So you don't get to just take a deal or plead guilty because that's what you want to do. When you were here before, you stood in front of that clerk, you put your hand up, swore that you were going to tell the truth, and I said, are you pleading guilty freely and voluntarily, or are you pleading guilty because you did what they charged you with?
I was, and I still am.
Okay. All right, Mr. Smith?
Judge, I think he's been given probation before. It was not successful. He's been revoked. The actions in the jail clearly show he doesn't have any respect for authority or rules. I don't feel like he's a proper candidate for probation, so we're asking for a 6-year sentence in TDC.
So, Mr. Lewis, one thing I noticed in several of these letters that friends and family members said, I think 3 of them actually used the word respectful, that you're a respectful young man. What has been going on in our jail is the furthest thing from respectful that I've seen. The number of times, and the fact that I have to say this out loud, the number of times that you choose to masturbate in front of the officers on purpose is ridiculous.
Can I speak on that, Your Honor?
Sure.
The case wasn't on me. Somebody else had a case, and the woman even talked to the lieutenant to get it removed up off of my file, but it still shows up. That was not on me. It's somebody
It's
else.
more than one time.
But I
So
don't-
hold on. So on April 14th, let's just go through them. On April 14th, you were in trouble for not being in your bunk, that you had been given several orders to go to your bunk. You proceeded to walk around yelling, "Bitch, stop talking to me." So that's from April 14th, last week. Then on April 7th, it alleges that you had your hands in your pants, moving in and back and forth, that you were told to take your hands out of your pants, and that you had been told before, or this officer had been briefed on the fact that you were known for doing this. Your response, according to this, is that that person should have asked the officers how big your penis, anyway. Since they want to be talking about you, they should have told them about that too. Then, on March 25th, before that, a week, so another officer, and these aren't the same officers, it's not the same person saying the same thing about you, somebody has some vendetta against you. So on March 25th, started to do rounds. Notice that you were watching the person doing rounds. Had his hand over his midsection as if he was rubbing on himself. March 18th, another different officer. Notice monitoring the bunk. There you are, laying on your back, stroking your penis in a back and forth motion, told not to do so. January 24th, 2025, you're in trouble for walking around. This one, notice the way you're laying on your bunk in a way, making motions under the blanket, walked past, turned around to see if you were still doing it. Then you supposedly look at this officer and say, "I'm not doing anything," while you lifted the blanket up for that officer to see it. January 4th, another time, being told to be quiet, do what you're supposed to do, didn't do it that day. December 29th, another issue of not following the rules. December 17th, another infraction for arguing and not following the rules. So if there was one time when they got the wrong person, that's one thing. That's over and over again, you disrespecting female officers who are in there just doing their job.
I sleep on my back.
Sir, we're really gonna do that?
You asked me and I'm telling you, I sleep on my back.
Uh-huh.
I have sisters, I have a mama, I don't do that. Them people write whatever they
They're
write.
making this up on
I don't
you?
have-
That's terrible of them to do
If
that.
you look at my cases report, ma'am, I don't have any cases on none of that. I don't have any time, I'm not on no restriction on none of that
Okay.
up in the county.
You were off parole, the way I do the math, less than a
I was on
year.
parole.
So you did your whole 8 years?
Yes, ma'am.
What'd you do in prison to have to do your whole 8 years?
I was in city,
For doing what?
just tattooing, contraband.
Not following the rules while you're in prison. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal, and you're lucky that this was the agreement. Mr. Smith was generous. The fact is, you could have been enhanced to.
And just like that, the gavel falls. 6 years in the Texas Department of Corrections. Judge makes it crystal clear. Past mistakes, jail misconduct, and a history of rule-breaking left no room for leniency. For Melissa Taylor, her own choices cost her freedom, and perhaps her child's stability. For Mr. Lewis, years of warnings ended in one final verdict. 2 lives, 2 very different downfalls, but the same courtroom truth. Actions carry consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe to Lawful Verdicts for more jaw-dropping courtroom breakdowns every week. Justice doesn't wait, and neither should you. Right here, we're seeing one of the most frustrating dynamics judges face: a defendant refusing mental health help while insisting they don't need it. Atkins rejects every evaluation, calls the program psycho stuff, and shuts down anyone trying to help her. But here's the legal kicker. Mental health doesn't excuse violation of probation, especially when treatment was part of her terms. The judge's patience is wearing thin, and you can feel the tension building. It's that moment in court where you realize compassion can only go so far when accountability is off the table. Would you agree the judge is being fair or too harsh here?
22, there was a motion to adjudicate probation filed. She entered pleas of true to counts 4 and 5. Does the state have testimony with regard to counts 1, 2, and 3?
Yes, the court would like.
Yep, I think I would.
Young man called, Ms. Shakita Cole.
Yes, ma'am. Good morning, Ms. Cole. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Ms. Cole, would you please state your full name for the record?
Shakita Cole.
How are you employed?
I'm employed at Jackson County Adult Probation.
And as a adult probation officer, is it your responsibility to supervise an individual on this court's probation by the name of Devin Atkins?
Yes,
Do you see Ms. Atkins in the courtroom here today?
yes,
Can you point to her identifier?
right here in the blue jumpsuit.
Your may the record reflect Ms. Cole has identified the probationer Devin Atkins.
Record will so reflect.
And Ms.
Printing.
Cole, as with every probationer, when they are placed on the court's probation, are they given the rules and restrictions placed upon them and what they are supposed to do to follow the court order?
Yes,
And each one of those in detail is gone over with them so that they understand everything that they're required to do.
yes,
Was Ms. Atkins so advised?
yes.
At her intake?
She was advised at her intake and at a TTM at the Melton Center in person.
Okay, and describe for the court what a TTM is.
A treatment team leader.
Okay, so in your opinion, Ms. Cole, as her probation officer, was Ms. Atkins fully apprised and aware of what she was required to do on probation?
Yes,
And were in fact a majority of those things intended to help her?
yes,
Was she advised that she was to report to the Community Supervision Department when directed by yourself in the court?
yes,
And did Ms. Atkins, based on your review of the file, fail to do that on multiple dates, including but most likely not limited to November 4th of 2024, November 19th of 24, and, and was that in violation of her probation order?
yes,
Did you address that with her and inform her, it is important to report, if you have something coming up, you need to let me know?
yes.
And did she do that?
No,
Was Ms. Atkins, as a condition of said probation, ordered to perform community supervision hours?
yes,
And did she, and to report those to you?
yes,
Obviously, if you do not know that she has completed them, even if she has, is that a violation of her probation?
yes,
To your knowledge, based on your review of her file and your supervision of her, did she either complete the hours or immediately report to you? Sorry, I'm reading that. No wonder everyone's looking at me.
I was
What are you
about to
talking
s- I know, I was
making
about
that
to,
community service? Well, that is in fact a condition of probation, right? Is it also a condition of probation that she is to report to you as her address and so that you know where she is all the time?
yes,
And if she does not do that, is it impossible for you to locate her?
that is
And
correct.
did she in fact immediately report to you her current address?
No, she did not.
Most importantly, based on Ms. Atkins' underlying offense and her issues, was she ordered or did she attend the safety program?
She attended safety, she completed the unit placements and the residential aftercares, but each time that she went for the supported outpatient, she didn't complete, so she didn't continue.
Okay, and was that failure to provide verification of attending safety a violation of her probation?
Yes,
And did that go hand in hand with her failing to successfully complete safety, which is to include any aftercare programs?
correct,
And she did fail to successfully complete the entirety of the safety program as ordered.
that's correct.
And again, addressing those issues, is she ordered to submit at your direction and court's direction to alcohol and or drug screening?
Yes, she is.
Was she ordered to do so on October 30th of 24, November 7th of 24, November 12th of 24, and November 13th of 24, and November 16th of 24?
Yes,
And to your knowledge, based on the review of her file, did she fail to do that?
she did fail to do that.
With respect to the entirety of Ms. Atkins' case, if I may, if this is the appropriate time, Judge, is there anything else? I know you and I have had a lengthy discussion about her that you feel would be appropriate for the court to know in conjunction with your testimony and your updated PSI.
The main thing is her mental health. She refuses to address that. We've made appointments for her with Spinal Tap, and she didn't attend the appointments. She's 100% when she was out unmedicated. So that kind of interfered with her completing her services. And she maintained contact with the victim in the case. So that part, her grandmother was trying to be there for her because of the mental health difficulties. And that's the main thing that we were trying to get her to address.
Okay.
Can I address something?
In a minute. Mr. Lewis, do you have any questions? Hold on, ma'am. You're going to get an opportunity, okay? Mr. Lewis, do you have any questions of Ms. Cole?
Just briefly, during your supervision of Ms. Atkins, were you able to supervise her at points when she was on her medication and not on her medication?
The entire time she has not been on her medication.
So she's been unmedicated this entire time?
Yes, sir.
Okay.
Anything else?
Nothing else.
All right. Thank you, Ms. Cole. Any other witnesses with regard to the allegations? Based on the testimony,
Unless I may ask, Ms. Cole, Judge,
Yeah.
and you stated that earlier, Ms. Evelyn Thibodeau, I believe that is her grandmother, correct?
Yes, correctly.
hold on, ma'am.
At some point in time in November of 2024, was Ms. Atkins violating the condition the court had imposed that she not to have contact with Ms. Thibodeau for Ms. Thibodeau's safety?
Yes.
Thank you, Judge.
Any questions about that? About
No.
the count, that's count 8 with the
Right.
contact? Okay. Then, at this time, based on the testimony, I am going to find counts 1, 2, 3, 6, 7, and 8 true. Again, there were pleas of true to counts 4 and 5 previously. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, ma'am, Judge.
Any additions or corrections to that report?
No, from the defense, Judge.
Nothing from the state, Your Honor, unless Ms. Cole has something to add.
Do you have anything to add that's not already in your report? So the main thing I want to make sure, Ms. Cole, I have a notation here to ask is, you guys were aware of mental health issues and had opportunities for Ms. Atkins to participate in mental health services. Is that correct?
I made the appointments myself for her.
Okay. All right. Argument, Mr. Lewis?
Well, Judge, I think definitely from the updated PSI we have, as well as I think there was some issues from the jail. If you look at those issues and activity, I think that goes directly to her mental health state. Unfortunately, she has not been on a mental health caseload. I think that definitely would benefit her, as well as, being able to take advantage of any services that Spinal Tap MHMR may have, or any programs that probation deems appropriate for her. I have had conversations with her, and meaningful conversations with her, where she has addressed to me her desire to take advantage of those activities if those available to me. She did understand that she had the Safe P opportunity. It didn't go well, but I don't think the mental health issues were addressed, mainly just substance abuse at that point. I think if we can get a handle on that, or get some work done with her to address the mental health issues, I think she'll do a lot better in this situation and be able to complete this assessment.
I mean, it's hard when
Hold
the
on.
is not taking patients.
Well, it sounds like you had appointments that you missed that Ms. Cole made for you. What, did she go to regular Safe P or special? Hold on.
Special needs.
So she's already been to special needs Safe P. So that was a whole 6 months plus aftercare of drug and mental health help. So Ms. Atkins, the problem is you're being given all the opportunities.
Yeah, but like I said, I don't know if I told you, I had an appointment in Port Arthur because I cannot get into Bowman. They're not taking new patients.
So you had an appointment that Ms. Cole set for you, at least one, how many?
Yeah, but it's not for medicine. It's for psycho. I'm not a psycho.
Welcome back to the courtroom, folks. And buckle up, because today's hearing gets tense fast. We've got Judge Stevens on the bench and Defendant Devin Atkins, a woman already on probation for injury to an elderly person. What should have been a simple compliance hearing spirals into chaos as her probation officer exposes a trail of missed appointments, failed tests, and defiance. But that's not all. Mental health, addiction, and denial all collide in this explosive session that ends with one of the most brutal judicial shutdowns we've ever seen. Let's dive into how it all unraveled inside this Texas courtroom.
I don't have those problems. I mean, some people do that. No.
Well, you obviously, we don't know what you need because you won't even go do the evaluation. That it sounds like you haven't been on medication that would be, what?
Evaluation where?
At Spinal Top.
That's what I'm telling you. That's not, I don't have that. I'm not a psychopath. That is for.
It's psychopath. Nobody's saying you're a psychopath, but you
that's
have.
what it's called, past program. I'm not a psychopath. That's what I'm
That's
telling you.
not what it's called, and that's not the reason it's called that, okay? If you had gone to your appointment and talked to them, then you would know what that was for, and you would know that it was meant to help you so that you could get on medication, stabilize, and not have the issues that you've been having. I'm going to find that you previously entered your, I'm sorry, Ms. Malfino, did you have anything to add?
No, Judge, I think that from my conversation with Ms. Cole, she's been gracious enough to offer to continue to work with her because I think she clearly sees the mental health issues. But as you can see, what Ms. Cole has been having to deal with is how the court has had to deal with Ms. Atkins today, and it's been kind of just this runaround circle.
Well, and in addition, I am going to find judicial notice of the court's file. Ms. Atkins was evaluated for competency to stand trial not that long ago. I think it was in January of this year. And I have that report. And the finding is that Ms. Atkins is competent, understands the nature of the proceedings, and is then just really making a choice not to follow through with what programs have been given to you, Ms. Atkins, to try to help you. So at this time, any recommendation as far as,
I have one more thing to say.
okay?
She is not giving me the information needed to follow up with those type of things.
Okay, well, I don't
She doesn't
believe
have
you.
them.
I don't believe you.
You don't
Ms.
believe
Cole
me?
would never say, go do something and not tell you where to go or help you get there.
No, she says she does not have a list of the community service.
I'm not worried about your community service. I'm worried about your mental health. And the fact that you're not doing what you need to, and you're still contacting the victim, and it's a serious case. And so I got to protect society, unfortunately, because you're not choosing to do the things
I feel
that.
like I was gonna die, so I really didn't have much of a choice.
Okay.
Is my life in jeopardy?
I'm going to find that you entered your pleas of true to counts 4 and 5 freely and voluntarily. Again, I'm finding counts 1, 2, 3, 6, 7, and 8 true. Find sufficient evidence to find you guilty, and at this time, find you guilty. Don't talk over. I'm about to sentence you to prison, and how you keep talking over me is about to start adding years onto that. Stop talking. It's just going to get worse. Do you understand? Okay. I'm going to find sufficient evidence to find you guilty, and at this time, I'm finding you guilty of injury to an elderly individual. Sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. No.
I'm telling you, like she thought, like I could not get up there.
I'm going to hand you the trial court certification that shows this
I would
was.
like to speak to a detective.
This was not an agreement, and so you waived your right to
said
appeal. I need you to sign that with
I gave you
her.
hospital papers. I gave her everything.
I'm also
I had
handed
a
you.
doctor's appointment and everything. That's what I'm
I've got
telling
5
you.
more years that I could add on to that.
Oh, yeah.
I can give you up to 10.
Have 'em.
You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I went to the hospital and everything.
I'm handing you a
3
written
times.
admonishment regarding your ineligibility to possess.
And there it is, 5 years in state prison. The judge had enough. After repeated warnings, missed chances, and outright denial, the court finally had to act. This case is a tough reminder that probation isn't freedom. It's a contract with the court. Break that contract, and you're walking straight back into custody. From ignored rehab appointments to mental health refusals, Devin Atkins's downfall was written in every missed opportunity. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Only here, on Lawful Verdicts.